when we enter this courtroom, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Therefore, this court's history has been so phenomenal, and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. What you're doing is, when there was no 10th schedule, what used to happen? The same thing. What my Lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified as a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, calling a trust vote has to be based also on alliances, if it's been reduced to a minority. That's accepted now by Rameshwar Prasad. They could have followed the Madhya Pradesh model. Resigned. No, but they wanted to be chief ministers and posts, so naturally, they could have followed the other model. That also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Quixote, unless we question Quixote.
I have always questioned it. But that's another issue,
But it also has a bearing on coalition governments,
yes,
particularly regional parties.
Yes.
Regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party, except for one leader. Many a times it's a family which runs it, and there is no scope of anybody else coming into the fray and setting up an alternative, because it's impossible. Virtually, we are interpreting the constitution to say that it is just not possible for any legislator.
In fact, this has been my grievance. What happens, in the United States and in the UK, a president, of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There is no such thing as defection. This is the problem. But anyway, we are in another era.
Yeah.
At the moment, we are on the law as it stands today. So we go back to the Gairam regime, when there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. There is an NCP case where only four people of the NCP actually went away. There were only 4 members. All of them went away. So it can happen.
So according to, going back to the Sarkaria Commission report, which was relied upon in Rameshwar Prasad, this was a post-electoral coalition of parties.
That's correct.
Of course, with the support of some independents as well.
Yes.
So according to it is only if any one member of the alliance and
Shifts.
or one member of the coalition shifts,
That's right.
that the governor can then say that, look, as a result of one party in the coalition, one member of the coalition having shifted,
Correct.
or ceased to back the government. Therefore, I feel now your vote in the your confidence in the House,
Yeah.
the confidence of the House in your government is now liable to be affected. Therefore, I call for a trust vote.
Therefore, he is not concerned with the 10th schedule at all, Malaj.
Right.
With the greatest respect.
Right.
Governor is not concerned with it. That's a separate proceeding. Whether they'll be disqualified, they may not be disqualified. If they vote against the whip, Malaj, within 15 days, I can condone it. Or if you have sent notices to 16, the others may say, now I don't want to lose my membership, they will come back. That arithmetic and that, Malaj, the consequences are not relevant as far as the governor is concerned or even the court is concerned. Court is to judge the act of the governor on the 28th of June, Malaj. Whether that was right or it was wrong. And I might say this to your lordships, Malaj. Malaj, when we enter this courtroom, Malaj, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power, Malaj, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Therefore, Malaj, this court's history has been so phenomenal and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. I'm sorry, Malaj.
But then taking your argument to its logical conclusion, that means that the governor cannot really have regard to any individual movement of a group or a number of MLAs or MPs.
That's Bomai, Malaj. Yes, exactly. Para 88 of Bomai says that.
Movement lies within the province of the Speaker under the 10th schedule.
Internal dispute he can't deal with. Para 88 of Bomai, Malaj. Intra-party disputes he can't deal with. It's in my note, I'll succumb to it. Chief Minister himself, I'll test it. These are the facts of Bomai, Malaj. Karnataka, which they relied upon. Because the Chief Minister said, I am ready to hold that test. And Para 3 was there on that day of the 10th schedule. And Malaj, what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There is no general principle that can be applied across the board. They can't be. Freedom of speech is a general principle. How you will actually, Malaj, recognize it is the context. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test and on relevant considerations. If you are able to justify that to the court, then the only remedy is a floor test. Let's kindly come to para 32. Thus, S.R. Bomai is not an authority for the proposition that the governor must order a floor test whenever a claim is made that the elected government has lost the confidence of the House, irrespective of whether such claim is based on unconstitutional or extraneous considerations. Rather, S.R. Bomai, it was categorically held that the power under 356 cannot be used to... Rather, in S.R. Bomai, it was categorically held that the power in 356 cannot be used to sort out internal differences in or intra-party problems of the ruling party. para 82. If your lordships will just allow me to show that, if it's convenient. Well, I'll show that here. Volume 2.
There's Bomai?
Yes.
We'll read Bomai here. You have extracted it.
Yeah, I've extracted it.
Yeah, we'll read it from your extract. Much easier. We've got Bomai, of course.
Yes, I purposely did it, Mala, so that otherwise
Yeah,
you'll have
We don't have to
flip
go
around.
back and forth at all.
You have extracted it also.
Yes, I've extracted it. It's okay. Well, it's actually, I must give credit to my colleagues.
Yes, yes.
Well, it's Mr. Tiwari, Mr. Devdutt, how wonderfully they have prepared this case. It's extraordinary. And I owe gratitude, sense of gratitude to them. Sort out internal differences or inter-party problems of the ruling party, and that exercise of this power for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution would be vitiated by legal malafides. You are now looking at an intra-party dispute. They have come to you, they are 34, I recognize you, I recognize the leader because he is the leader. So the governor is I'm sorry.
Mrs. Sibal, just give us a moment. There was an urgent order which
No.
I'll just show it to my learned brother Justice Narasimha.
That's the morning.
Yes.
Sir. And this intra-party quotation is from Sarkari Amalats. It is adopted by Bomai. And it is consistent with those propositions, Malats, that I read to your lordships of Sarkari Amalats adopted by Rameshwar Prasad. See, you can't enter into moment you say, okay, I'll recognize these 3 people, I will entertain these 2 people, and then now you have lost majority, now you have a floor test. Impermissible. That's the old non-10th schedule regime, the Ayagram, Gayaram regime. Then crucially, para 34, S.R. Bomai, Justice Jeevan Reddy further observed in the context of the 10th schedule that we're equally of the opinion that the High Court was in error in holding that the enactment of 10th schedule of the Constitution has not made any difference.